are you reasonably convinced that the amendments, proposed amendments, will strengthen the financial creditors over the operational creditors?
Yes, I believe so. I believe that this is essentially to calm the issues which have arisen as a result of the NCLAT judgment.
Okay, they don't state it very clearly. The statement is that people will get liquidation value.
No, no, Lata, it's very clear because they refer to section 53 of the IBC. Now, 53 of the IBC is the waterfall. And in the waterfall, where the process is sort of clearly mentioned as to who gets what in priority, the secured financial creditors are the ones who get priority over every other unsecured creditor, and therefore whether it's a financial unsecured creditor or a operational creditor, which will obviously be an unsecured creditor, the importing of the 53 principle would show that the financial secured creditors will get priority.
Okay.
It's very clear.
Sure. VG Kannan also joins in.
They've also mentioned that they have also mentioned that this will be with retrospective effect where there is where the proceedings have not received finality or are pending before any authority or before the appellate authority or Supreme Court or High Court, wherever. It is retrospective only to the extent that the resolution is not closed, but where the resolutions have closed, there is no question of opening them on this ground.
Okay. Mr. VG Kannan also joins into the discussion. Mr. Kannan, good morning. What are your own thoughts? I mean, do you think that this will aid a faster debt resolution, especially for cases like SR?
First of all, I think it is a slightly marginal improvement over the existing provisions, because I thought it was very clear in the earlier IBC also that the financial creditors will have a priority over the operational creditors. But for reasons best known to the people, the NCLAT decision was quite contrary to that, and they gave equity to both the financial creditors and the operational creditors. And to that extent, I would say it's more of a clarity which has been provided. And as regards the number of days which has been given, 330, it's an extension of another 60 days. When things have gone much, much beyond 600 days or even 700 days, I don't know in what way this deadline of 330 days will really be applicable. And what actually will happen after 330 days? Does it automatically go into liquidation? Or whether the NCLT and NCLAT can further...
We just lost connectivity. We'll redial with Mr. Kannan. Shardul, do you think now for the SR case there is some finality? We understand that the hearing in the Supreme Court is scheduled for July 22nd, with the Parliament having reasonably indicated its intent now on what it meant by the distribution of proceeds. Is there a better chance for the banks on July 22nd?
I personally feel that unless this becomes law, the Supreme Court will have to decide on the basis of what was or should have been the actual basis of making a decision, because the Supreme Court will take into cognizance intent of the government and its clarification that this was always the case, because the amendments made or proposed are all in a sense clarificatory in nature, and therefore to that extent the court can take it into cognizance or it will wait for the law, but it can decide independent of the bill. Supreme Court can also decide on the basis of what it believes should be done. So all possibilities exist. It's not as if just because of the bill the Supreme Court will go one way or the other. The Supreme Court can take up a position that, look, this is clarificatory and therefore we will take that as the intent of the legislature and go ahead on that basis, or it can decide whether this principle that you cannot give unsecured creditors amounts in excess of or equal to the secured creditor. That's a matter which the court can come to a conclusion independently also.
Okay. Shardul, this 330
The higher probability would, the higher
Yeah, go ahead.
Go ahead.
Sorry. See, the higher probability is that the Supreme Court will effectively, after the bill is out into public consideration, will take into consideration what the government is intending or the Parliament is intending, and it will come into the reasoning process of the court when it has to decide on the civil appeal.
Okay. No, I wanted your thoughts on this 330-day sacrosanct time limit. How much of a difference will this make to, bring back time-bound resolutions and, more importantly, avoid unnecessary litigations?
See, if you've read the fine line of the press release, it says 330 days inclusive of judicial time spent in the process. So, yeah. So what they're basically saying is 270 days plus 60 days. 2 months is the maximum time that they are giving as a part of the judicial process, and they will have to have provisions which bring a closure of the proceedings at the end of 330 days, so that it's clear to the appellate authority or the adjudicating authority or anywhere that this is a fast-track mechanism and is not amenable to prolix arguments where you can go on and on and on, because there's a time cost of the process. There are two other very interesting proposals in the press release. One is that even admissions are going to be subject to a strict timeline. Today in the Bombay tribunals, sometimes you don't get a listing for 4 months, just the listing of the application. So obviously there will have to be some timeline there. And the second thing which is there towards the last clarifications for the amendments are that a committee of creditors can decide any time up to the information memorandum date to withdraw from the CIRP by appropriate resolution by majority, and ask the adjudicating authority to take it straight to winding up. So these are the 2-3 mechanisms which have to be read together. Okay. If, for example, it's going to go beyond 330 days at the adjudicating authorities level itself, they can take a decision that my time value of money is lost and I want to terminate the process and straight away go to winding up. So this gives in some sense a balance of convenience to the creditors to take a view as to whether they've had enough of this whole delayed process and whether they want to close. Okay. And go to winding up.
Okay, well, often that's not much of a help because you get even less money if you did that. But yes, at least the option is available. Mr. Kannan, before we lose connectivity again, for you, what are the key takeaways as a banker? Are you expecting recoveries to speed up?
I think the IBC process itself was expected to speed up the whole thing. And the initial cases did sort of find the resolution early, but what has transpired thereafter, there has been delays. And well, there is, as Shardul also mentioned, it's a clarificatory amendments which have come. Whether it will actually speed up, I don't know. But yes, at least in the case of the one which has gone to the Supreme Court, there could be some clarity quickly. And there has to be some timelines for the people to also adjudicate. But in the event 330 days gets over, what is to be done? That's not clear. Does it mean automatically it goes into liquidation?
Yeah.
Or is there a possibility of the creditors to appeal to saying that we will want another 30 days or 60 days? Because very often you find that for various reasons the things have been delayed.
Yeah.
And the actual resolution is not even put up to the NCLT because of the litigations. Okay. Then what happens?
A good question. Actually, let's ask Shardul that. What if it is 330 days?
That's what I'm saying. If 330 days...
No, I'm just asking... no, Mr. Kannan, I wanted Shardul's reply to that.
Yeah, so normally if they prescribe a very specific time date, like they had 180 days or an extension of 90 days, which they said can only happen once. If you see the provisions, the section is itself very clear that it is limited to one extension of 70 days. Now, if they have brought in the concept of 60 more days because of judicial time spent, they are taking into consideration all previous case law where the courts have effectively said, I will take my time and deliver. They have clearly said that having read your legal position, having read the fact that you are going to exclude judicial time, we are still telling you that, sorry, even if you exclude judicial time, that time cannot be more than 60 days. And to answer Mr. Kannan, essentially what the principle that they'll have to indicate is that if you go beyond 330 days, it abates. Now, if it abates, which means that the proceeding becomes non-existent, then obviously it will go to compulsory winding up. If as a result of exceeding 330 days, then the consequence would be that the proceedings for resolution will come to an end and it will go straight into liquidation.
Well, we will discuss this at length.
This is a cut-off date now. It's an absolute cut-off date.
Okay, I just wanted...
which basically says, finish your process in 330 days.
Okay. I just wanted one quick comment from you, Shardul, on the amendments to the Companies Act. It is going to make a bunch of minor offences as civil defaults and not criminal. Generally, if you looked at the Companies Act amendments, is there some more joy?
I think... No, I think there's a misunderstanding here. There were 3 ordinances and 1 bill in relation to the exact companies bill which is now introduced. So this is in a sense existing law which lapsed by virtue of the ordinance lapsing. And there is nothing new to this. It's a repetition of previous law which by virtue of the session ending, the bill had passed the Lok Sabha, the bill didn't go through the upper house, and therefore it had to be reintroduced. So there is nothing new in this piece of legislation.
Fine. That, with a relief, we can then not look at further changes in the law.